Good morning. Welcome to the Michigan Hall of Justice and our March 20th public hearing. Our first item today is a proposed rescission of administrative order number 2020-17 and proposed amendment of MCR 4.201. We have a few speakers that I believe are appearing by Zoom. Our first speaker is Kim Kramer from Michigan Legal Help.
Good morning, Justices. Thank you so much for the opportunity to comment this morning. My name is Kim Kramer, and I'm a lawyer at the Michigan Legal Help Program. First, I'd like to thank the court for continuing to look at changes to court procedures that were implemented during the pandemic, and for keeping the changes like this one that are consistent with principles of fairness and access to justice for all. I'm here to express Michigan Legal Help's strong support for this proposed change. It would be a more permanent suspension of the 5-day rule in courts all across the state. As you know, before the pandemic, a relatively small number of courts had a 5-day rule in place, and in these courts, tenants could be defaulted if they did not file a written answer within 5 days of being served with an eviction complaint. The amendment clarifies that courts may not require a written answer and that all litigants must be allowed to appear and answer orally, as has long been allowed by the Michigan court rules. We support this change first because it increases access and fairness in the courts, and second because it helps us to provide accurate legal information to people everywhere in Michigan. So on the first point, requiring a written answer before allowing tenants to appear in court is a major burden, especially when the deadline is as short as 5 days and service by mail is complete at the time of mailing. And so tenants in these jurisdictions who were served by mail might have a day or two to file a written response. Only about 5% of tenants in eviction cases have lawyers at all. And in this really early stage, it's even less likely folks would have a lawyer. Many are still in the phase of contacting and waiting to hear back from legal aid, or maybe attempting to find a private lawyer they can afford. And so requiring tenants facing eviction to file a written answer within this short timeline is essentially cutting off access to the courts for a large portion of them. On my second point about consistent procedures across courts, especially around basic pleading requirements, this is essential to allowing organizations like mine to provide statewide help. The Michigan Legal Help website did provide information about the 5-day rule jurisdictions when the rules were in place, but that also required our site visitors to select county-specific information and to carefully read and understand caveats. We know that the average American reading level is around a 7th or 8th grade level, and the more exceptions and special rules we add into our explanations, the harder it is to make our information readable and accessible. And this applies to everyone looking for housing information, not just the folks in the 5-day jurisdiction. So these outliers in a small number of courts muddle the procedures for everyone in this state. So in short, we support this change and we hope to see the court adopt the proposed amendment as written. Thank you again for the opportunity to comment today, and if anyone has any questions, I'm happy to answer.
Any questions? Thank you very much. Our next speaker is Shannon Lucas from the Michigan Advocacy Program.
Good morning, and I would like to also express my gratitude for being allowed to be here today. My name is Shannon Lucas. I'm the Director of Advocacy at the Michigan Advocacy Program, and I am here this morning on behalf of MAP, the state planning body, and the Legal Services Association of Michigan. The Michigan State Planning Body is an unincorporated association of 43 individuals, leaders in the judiciary, the state bar, the state and regional advocacy programs, and community organizations who are interested in Michigan's indigent civil legal aid and indigent defense systems. Michigan State Planning Body is committed to assuring equal access for the poor to the legal system, including the eviction defense work. Legal Services Association is made up of 11 of the largest civil legal aid organizations in Michigan and collectively provides legal services to low-income individuals and families in more than 50,000 cases per year. Eviction defense is one of our highest priorities and need. LSAM members are committed to providing fair and equal access to the justice system for low-income individuals. And to talk a little bit about MAP, MAP is one of the largest legal services organizations in Michigan. We provide free legal services to low-income residents in 13 counties throughout mid and southeast Michigan. In 2023, MAP closed over 9,000 cases. Of those cases, over half, or 4,808, were housing-related cases. Throughout COVID, legal services programs worked tirelessly to represent tenants through eviction diversion programs set up in district courts. These programs benefit both tenants and landlords by ensuring access to the court, access to rental assistance as needed, and the fair and efficient court process. But the key to these programs is the ability for tenants to appear in court and not be defaulted before that hearing happens. I personally worked in 2 counties, Monroe and Lenawee, where specialized court rules regarding housing were implemented. This included the 5-day rule. These counties are very rural. They do not have public transportation. Getting to and from court is often a challenge, made even more difficult when you have to get there in such a short period of time. The local court rules also created procedural hurdles that many clients couldn't navigate, and one violation was often fatal. Many tenants were unable to comply with the written answer requirement to get to court within that short period of time. But even the tenants that did, in our experience, who were successful in filing a written answer, would still lose their right due to other aspects of the rule. Either their answer was reviewed and determined to be insufficient, it was on the wrong form, it wasn't legible. All of these things could result in a default for the tenant. The net result of these rules is that a very high percentage of tenants lose their cases without ever having the opportunity to appear in court and access services. The majority of tenants appear without counsel, as Ms. Kramer highlighted. Self-represented litigants face unique barriers. Many are intimidated by the court process or have already had negative interactions with the court. The 5-day rule increased inequities in the eviction process and based on where the tenant lives. We believe that this final amendment completes the court's review of summary proceedings in a way that is consistent with the lessons learned throughout the pandemic and the values of the JFA program. We urge the court to adopt it. Thank you.
Thank you very much. I don't see any questions. Thank you for your time today. Our next speaker is Kelly Mackey-Foster from Lakeshore Legal Aid.
Hi, good morning. I am Kelly Mackey-Foster. I am the Detroit Eviction Prevention Director at Lakeshore Legal Aid. I echo the comments that were made by Ms. Lucas and Ms. Kramer, and also my gratitude to the court for considering this amendment. Lakeshore Legal Aid is the largest legal aid provider in Michigan. It serves Oakland, Macomb, and Wayne counties for low-income people, victims of sexual assault and domestic violence, and seniors. Our call office, the Counsel and Advocacy Law Line, does intake for people across the state of Michigan, both providing intake services for the other legal aid organizations, but also providing brief services. I also am a member of the Justice for All Subcommittee on Housing, the State Planning Body's Committee on Housing, and I'm a board of director on the Michigan Coalition Against Homelessness. I've worked at Legal Aid for the last 20 years and have been a housing attorney at that time in multiple jurisdictions around Michigan. In my experience as the managing attorney of the Lansing Office of Legal Services of South Central Michigan, we covered the Mason Court, which had a 5-day rule in place while I was there, and it was rescinded during that time as well. I did a written public comment. I'm not going to rehash everything that I laid out there, but I do want to highlight a couple of things. And so one is that the summary proceedings is an accelerated timeline. It moves the fastest of any lawsuit in the state of Michigan. Recognizing the fast processing of eviction cases, the Summary Proceedings Act allow a defendant to answer orally and defend allegations in the complaint under 4.201G1B. The accelerated timeline, I'm sorry, I moved over here. Here we go. I don't know the number of cases in summary proceedings that move forward without a defendant filing an answer. In my experience, a far greater number appear for their hearing and assert their defenses orally. And often, if there is even an answer that's filed, it's after the first hearing. Tenants in 5-day courts do not receive the benefit of the advice and rights under 4.201K, an amendment designed to promote the fair administration of justice. The 5-day rule unfairly puts the onerous for the lawsuit on the tenant defendant. A high number of those tenants lose their cases without ever having the opportunity to appear and state their case. This leads to a higher rate of defaults. Default judgments that are entered into without the inquiry of the merits of the case, or the landlord having to say that they're entitled to the relief that they're seeking. The burden to set aside a default judgment is high, and it's very much higher than the burden of just appearing orally. I appreciate this court hearing these comments. I want to note that there was no written comment opposed to the amendment of this rule. This rule puts all tenants in all jurisdictions in the same position. The court is charged with providing equal access to all and access to justice, and this amendment helps achieve that. Thank you.
Thank you. Thank you so much for your time today. Our next item is item number 2, administrative file number 2022-19. Several proposed amendments and proposed additions to the Michigan Rules of Professional Conduct that would amend the rules governing IOLTA accounts. And we have a number of speakers for this item as well. First is Kimberly Uhuru from the Attorney Grievance Commission.
Good morning, Chief Justice Clement and Justices of the Court. The Commission would like to express support for the proposed changes, especially the addition of a comment regarding the removal of earned fees from the trust account within 30 days. This is an issue that we see frequently in disciplinary investigations, with lawyers sometimes holding their own money in client trust accounts for extended periods of time, from weeks ranging into months and years, which leads to problems with record keeping, problems with commingling. So we believe that this addition to the rule is a good step forward, and that the guidance and the commentary will help address this problem. The Commission has also proposed additional revisions to the rule in our written comment, which we hope the court will consider. Of the 4 suggestions in our written comment, the one we would most strongly urge the court to consider is the first revision regarding the use of client trust accounts as general operating accounts by attorneys, or even as personal accounts by attorneys. This is another issue that we see emerge frequently in disciplinary investigations. And typically what we see is we'll have an overdraft notification from a bank where we will submit subpoena several months of bank records from the client trust account, and it will show instances of the law firm operating expenses being paid from the trust account. So payroll, utilities, things like that, and sometimes even personal expenses. These are things totally unrelated to client matters or representation, and it's completely inappropriate for them to be coming out of the client trust account. The funds should be transferred to an appropriate business operating account or personal account, and then pay the bills from there. In our experience, this use of the trust account may expose funds in the account to claims by the IRS or other creditors. Although there are some attorney discipline board decisions which address this practice, it's never been directly addressed by the court rule itself. Therefore, we're urging the court to adopt a clear prohibition on this practice in the rule. There were some other suggestions in our written comment that I won't belabor here. I'd appreciate the court's time, and I'm happy to answer any questions if you have them. Thank you.
Yeah, counsel, I actually do have a question. I was just wondering, I know the draft rule has landed on 30 days as being the time period before, I guess, the money can be billed. Understand that's a reasonable time for a client to look at the bill and dispute it. I'm wondering, is it your opinion that a clear retainer agreement could make the time shorter? And the reason I ask for that is the whole purpose of a retainer agreement is to get prompt payment. And I know a lot of engagement letters require payment, in maybe 2 weeks or something like that.
Right.
And certainly in the non-legal sector, that's very common. So I just was wondering, could a retainer agreement say that it will get charged after 15 days? It seems like under the rule it couldn't, and I'm just sort of questioning if it has to be 30 days.
I don't think the rule would prohibit that. I read the rule as saying that the attorney has the burden of removing their own earned fees from the account within 30 days. Well, 30 days will be considered a reasonable period of time. I think a 2-week period would be fine if the client is advised. And really, we want to see the funds come out of the account as soon as possible because we want to avoid commingling, right? So the concern of the commission is that once the bill has been settled and there's no dispute, the attorney promptly, really immediately removes those funds. We want to give attorneys time to review their bank statements and do their trust accounting. But the problem for us is really on the other end when the attorneys leave their earned fees in the account indefinitely. And what we see is attorneys doing that sometimes to shield those funds from creditors because they're in a client trust account. They actually don't want to move the funds into a personal or business account because then they'll be subject to liens or garnishment or things like that. So what we see generally is the opposite, where attorneys are leaving the earned fees in the account for a very long period of time, sometimes for improper purposes, and then the funds are all mixed up and the attorney's not doing trust accounting, and that's when we see the trust account notices coming from the banks. So to your point, I think a situation where the attorney is moving them quicker rather than later, within 2 weeks or within a few weeks, that actually is a good thing because it gets the funds segregated, and a clear retainer agreement can help facilitate that.
Okay, and then my other question is, and I believe we will hear more from Mr. Allen about this, there's sort of this notion of, I guess I would call it, the retainer that puts you as an on-demand attorney. You're paying for the right to have immediate access to your attorney. And I think a solution that has been presented here is that money is considered sort of earned right out of the gate pursuant to a clear engagement agreement. And I think it's your position that would not go in the IOLTA then, that would just go into the normal operating account. Is that correct?
Right. If the attorney has an engagement agreement, attorneys use all kinds of language for this type of agreement, but generally a retainer agreement or engagement fee where it's clearly communicated to the client that the fees are earned upon receipt. In other words, the fees are just for the attorney's availability. They're not for work that the attorney is going to do in the future. If it's clear in the retainer agreement that the fees are earned upon receipt and client agrees to that, then those fees should go into the attorney's operating account and not the trust account because they belong to the attorney, once they're paid, and they're not something that's being charged on at a later date.
Okay, so yeah, I'm just like from a practical standpoint thinking about how attorneys manage that because they still are, yes, you're paid to be available, but they're also still charging against the amount that was provided to them.
Right.
So
this goes to one of the problems with
yes.
non-refundable fees and engagement fees. A lot of times it's not clear to the client. Attorneys don't make it clear in their retainer agreement that the funds are just for availability. And the client thinks, well, you're going to show up to my arraignment, and then you're going to bill, and then you're going to show up to my pretrial, and then you're going to bill. And the attorney is treating that as earned upon receipt. We think it just needs to be clearly spelled out to the client in a written agreement so that the client understands that they're paying only for availability. And then once both parties agree to that, then that money should go into a non-trust account because those funds no longer belong to the client.
Yeah, and I guess I could see the situation where you pay someone $10,000 to handle your criminal trial, and then very early on, well before trial, things break down, and the attorney's probably put 4 hours in, hasn't earned the full $10,000, maybe depending on what their rate is. That would be high, but I could see obviously reasonable demand to have a refund, of course. So I sort of wonder then if, as long as the attorney just puts in there, I'm just here to be here on demand, that feels like that doesn't sit right with me. At the same time, I fully recognize the whole notion of someone who maybe has to check in with a criminal defense attorney on a regular basis for whatever reason. Being on retainer, I think of that more like multiple incidents, more question, maybe there's not even a pending criminal matter. They're making sure something isn't criminal. So I recognize these are hard lines to draw, and I want to make sure, of course, that clients can get their, money back if services haven't been provided, but also recognize that attorneys have the right to have sort of on-demand agreements. So Thank you.
Right. Thank you.
Any other questions? Thank you very much. Our next speaker is Alicia Chandler from the State Bar of Michigan.
Thank you, Your Honors, and Justice Clement. My name is Alicia Chandler, and I am the Professional Responsibility Programs Director for the State Bar of Michigan. The proposed amendments to 1.15 were submitted to this honorable court by the State Bar of Michigan at the request of the Professional Ethics Committee. The committee recognized that based upon the numerous requests for guidance regarding lawyers' compliance with 1.15, the clarification would provide that much needed guidance to our members. The work group included members of the Attorney Discipline Board, Attorney Grievance Commission, State Bar Foundation, State Bar of Michigan ethics attorneys, and volunteer members of the Professional Ethics Committee. And that resulted in the proposal you have before you today. The revisions are numerous, but the Professional Ethics Committee believes that they do not expand the duties of the lawyers acting as a fiduciary when holding client funds. Instead, these revisions just provide clear language so that the lawyers better understand those duties. For example, there are revisions to MRPC 1.15C, which were just noted. And I want to quote from the comments that states, if funds are not yet earned, the funds must be deposited into an IOLTA or non-IOLTA. This is the current rule. Based upon ethics opinion RI-069, which I know is simply guidance, but it is the guidance that we provide to the lawyers that call us on the helpline or request ethics opinions. That provides that a fixed fee for service to be performed in the future must be placed in a client trust account. The members of the work group agreed that members of our profession often believe that using the title fixed fee, retainer, or otherwise puts the client on notice that the fee is a non-refundable fee. But this does not comport with this court's order in the Grievance Administration v. Cooper. The fee agreement cannot be ambiguous. So the comments that we have provided, including that if it's a fixed fee, flat fee, is to simply say to the lawyer, you need to do more if you expect it to be a fee that is earned upon receipt. You can do that within your fee agreement. You just can't simply use the title fixed fee, classic retainer, or something like that, because clients don't understand that that title makes it implicitly a non-refundable fee agreement. And also, lawyers use these titles interchangeably, as Ms. Uhuru just indicated. So, and they attach different meanings to those titles. So how can we expect a client to understand that a title means something is earned upon receipt if lawyers don't even agree? So that was not meant to change or alter the current rule. Instead, provide lawyers with a little bit of additional guidance on what they must do to ensure that they are placing those funds in the correct account. The next section that I'd like to briefly address is MRPC 1.15B. It delineates the required records that must be maintained for a lawyer to meet their fiduciary duty in holding a client or third-party funds. It's our position that this does not expand the duties of the lawyer. One commenter noted that financial institutions already maintain bank records for the lawyers. However, the lawyers cannot abdicate their responsibilities under 1.15 to a third party. And again, ethics opinion, R-22 states this. Again, that's not binding on this court, but we still think that it's important. And moreover, the financial institutions have no requirement to maintain this documentation on behalf of the lawyer. And we have seen instances on the Client Protection Fund, and I believe that the Attorney Grievance Commission has as well. Obtaining these records can be incredibly difficult, particularly in instances where there are bank mergers, accounts have been closed, and then we also have the matter of the person-to-person payments that are not easily tracked going into and out of bank accounts. So it can make documentation difficult to retrieve, and more importantly, it can make it difficult to do that proper accounting for the client, which we have a duty to do if we're holding their money. We are acting as a fiduciary. This goes beyond our traditional lawyer setting of representatives of clients. Additionally,
I'm
MRPC.
sorry,
Yeah.
I apologize for interrupting you. You're beyond your time limit.
Okay,
Let me see
thank
if there's
you.
any questions. I don't see any. Thank you very much for being with us
Okay.
today. Appreciate it.
Thank you.
Our next speaker is John Allen, who's here in person.
Madam Chief Justice, Justices, good morning. It's always an honor and a privilege to be here. My name is John Allen, Varnum Attorneys. I submitted some comments. I urge you to review them. I'm not going to repeat them, but I do want to emphasize a couple of legitimate fee devices that could run into trouble with some parts of this rule. In the Orwellian sense, all the rules are important, but some are more important than others. And the trust account rule is likely the most important of all. Any lawyer can tell you any violation of that rule in any respect, even though it's completely innocent, even though it's an administrative error, is very likely to draw some attention by the AGC and some discipline, at least in one of the minor forms. Can be a permanent record for the lawyer. Lawyers are very careful about this, and we need this rule to be crystal clear. A couple of fee devices could run into trouble. One is the classic retainer, the one about which Justice Welch asked a question. That is where the lawyer accepts an amount of money in return for a promise that the lawyer will render services upon request and further agreement with the client. That has two very serious implications. One, under the fee rule, 1.5A2, it is reasonable to do that, sometimes in a very substantial amount, without any services being rendered for it, because under 1.5A2, there is a likelihood, if not a certainty, that the lawyer and all the members of the lawyer's firm will be precluded from any employment that is adverse to that client under the conflict of interest rule 1.6, or if the client leaves 1.7. That is a very substantial commitment. That's why not only custom and practice, but virtually all of the prominent commentators conclude that that classic retainer is property of the lawyer upon receipt. Under this rule as it's written, and particularly under the comment for advance payment rules, it says that any retainer, by whatever name or title, must be deposited first in the trust account. If a classic retainer, in my opinion, is deposited into the trust account when it is the lawyer's personal money upon receipt, that violates the trust account rule. That's the very commingling we're trying to prevent. And I think some serious clarification needs to be done to the rule in that regard. The second fee device, which is very common as a custom and practice in certain areas, is to charge a fee, sometimes a substantial fee, in advance of the first meeting with the client for the same reasons, and that is merely meeting with the client will likely preclude the lawyer and all the lawyers in that firm from taking any engagement adverse to that prospective client that makes the payment. Areas affected by this, to my knowledge and in my experience of a half century of practice, would include especially family law, litigation, trusts and estate contests. And it's because there's a perverse practice believed to occur that some clients, having already retained a lawyer, will nevertheless call another lawyer, make an appointment with that lawyer, be sure to disclose some protected or confidential information in that meeting, and then be able to claim that that second lawyer visited is prohibited from any representation adverse to that client. I have been personally victimized by that tactic. If you attend any ICL-CLE conference in those areas of the law, you are going to find panelists reciting that they believe they have been victimized by it too. So we find that if the client is charged sometimes a very substantial fee, a prospective client, before the first meeting, that's a good test. They aren't willing to pay that much for it usually, if that's their malevolent intent. And often, as Justice Welch noted, after that first meeting, many times the lawyer and the client will then enter into another agreement that says, hey, part of that money you paid before the first meeting, we'll put it in the trust account. We'll treat it as an advance payment of fees. We'll account for you as the fees are earned and allow it to be part of the fees that are credited to your account here at the law firm. I've suggested a couple of potential amendments. My language is not magic. There may be smarter people here that are able to come up with something better. But I do think 1.15C should be clarified to state that a classic retainer or a fee paid in advance of a first meeting and as a condition to that, if otherwise reasonable, under 1.5, should be permissible. I think also the comment, comments are not the law. You repeatedly tell us that they're there to aid us. They're there to assist us, but they are sometimes sources of mischief because they are cited by lawyers, by courts, sometimes by this court, for a meaning of the rule. And that's why I think the comment also is something that needs to be crystal clear, and that the particular comment on fees paid in advance would benefit from a clarification that says this doesn't apply to a classic retainer or a fee agreed as a condition to a first meeting.
Mr. Allen, I'm going to stop you and just see if there's any questions. Justice Welch, do you have any follow-up?
Yeah, I do.
Thank you.
So thank you. Thank you, Mr. Allen. I have found your comments to be very helpful and reflective sort of real life on how it works, because I too know exactly what you're talking about as far as the attorney shopping. So what you call classic retainer, is that the same thing as like an unambiguous non-refundable fee? Would that could we just call it a non-refundable fee?
Yes, I would encourage the court to refer to the ABA formal opinion. It was attached to Mr. Cito's comments, so I did not reattach it to mine, although I cite it there. It has a good explanation of what a classic retainer is. It goes by different terms. I can tell you, Your Honor, that smart lawyers these days don't use the word non-refundable when they're describing their fees, all right? That's something that gets the attention from the AGC people, whether it deserves it or not. But yes, I think it would be, in effect and in truth, a non-refundable fee.
Great, thank you. And then you raised an interesting point that many attorneys then sort of convert that meeting fee or whatever it's called into a more traditional retainer agreement where then the money gets put in, sort of transferred over to the IOLTA. So from a practical standpoint, just administration, how this will work for law firms, you're a family law attorney, you're going to charge $5,000 for the first meeting. And they get the meeting, they pay the $5,000. That $5,000 then goes in the general operating account, correct? It does not go in the IOLTA.
Yes.
Correct. And then,
that's correct.
Right. And so then you're saying after that, they get I am officially retained, we are moving forward in you are not just consulting with me, I'm going to represent you in your divorce. At that point, then they can do a new agreement, which then says $4,500 now gets moved over to the IOLTA. Okay.
Or even the entire amount. And it should be a new agreement. And the client should be reasonably informed about what that agreement is, preferably confirmed in writing. These days, sometimes that's an exchange of emails.
Sure. Yeah, I'm just trying to, we heard a lot from small firms who, these layers can be, onerous. So I just want to make sure we are very clear on what can and can't be done so that they know the rules especially. So thank you. This is very helpful.
Well, and I thank you very much for the question, because it illustrates that if a justice of the Supreme Court has a question about that, lawyers are going to have it too, and this might deserve a further clarification.
Thank you.
If there are any other questions?
I don't see any. Thank you very much.
Thank you very much, Your Honor.
Next speaker is Jennifer Bentley from the Michigan State Bar Foundation.
Chief Justice and Justices, I'm Jennifer Bentley, the Executive Director of the Michigan State Bar Foundation, and thank you for reviewing the proposed modifications to Michigan Rules of Professional Conduct and giving individuals an opportunity to comment. The Michigan State Bar Foundation administers the IOLTA program, And in addition to our responsibility in assuring good stewardship of the funds received in the terms of grants and grant investments, we also view it as our responsibility to assure accounts are set up correctly, IOLTA accounts are set up properly within financial institutions, and that we're able to track and identify IOLTA accounts to the attorneys and the firms holding those accounts. We also view it as our responsibility to monitor compliance of financial institutions with the eligibility requirements that are set out in the current rule. I participated on the work group that reviewed and proposed the modifications to the rule with the intent to provide clarity and modernize the rule. My participation was based on our involvement with, or our administration of the IOLTA program, and the questions the foundation receives both from attorneys and financial institutions regarding those IOLTA accounts. I think the modification to the rule provides clarity to the distinction between approved and eligible financial institutions that already exists in the current rule, but that because of 1.15 and 1.15a being added later, the proposed modification provides clarity to what could be confusing in the current rule. I support the rule change in terms of the IOLTA provisions and can answer any questions regarding IOLTA that you have.
I don't see any questions. Thank you very much.
Okay, thank you.
Appreciate it. Our next item, item 3, is ADM file number 2022-24, proposed amendments of MCR 6.907, 909, 933 that would clarify that youthful inmates should not be placed in isolation in order to keep them separate from adults. We have one speaker, Taylor Fellows from the State Appellate Defender Office.
Good morning, Chief Justice, Justices. I'm Taylor Fellows. I'm an assistant defender with the State Appellate Defender Office, here in support of the proposed amendments to the court rules, which would reduce the use of solitary confinement for youth who are held separate from adults in adult facilities. While solitary confinement has been previously touted as a means of discipline or protection, the United Nations and various human rights organizations today recognize it for what it really is: torture. The practice of isolating and confining individuals has been shown time and again to inflict enormous and irreversible psychological, physical, and developmental harm in adults. Today, we have a growing body of research that has explored the effects on children, finding that the harms of solitary confinement are particularly acute. It's been shown to exacerbate mental illness, increase suicide rates, decrease educational opportunities, and stunt development. In addition to causing trauma and damage when inflicted upon children, studies have also shown that solitary confinement fails to deter future rule violations or violence, but is instead associated with increased recidivism. We've also learned the stark reality that this practice disproportionately affects marginalized children, including children of color, children with disabilities, and children of the LGBTQ community. Outside of their overall increased presence in the justice system because of over-policing and bias in the system, these populations are often subject to isolation under the guise of protection or due to systemic failures in providing adequate support and accommodations. These proposed amendments come at an extraordinary time where across the country courts have held solitary confinement is unconstitutional when applied to children. And over half of the states and the District of Columbia have placed restrictions or prohibited the practice altogether through statutes, administrative code, or court rules. The results of these reforms have spoken volumes. In the case of Ohio, a staggering 88.6% reduction in solitary confinement of youth corresponded with a notable decrease in violence within facilities of over 20%. Zeta was encouraged by this court's decision to bring Michigan law in compliance with federal regulation and our neighboring states regarding the use of solitary confinement of children. I'd also like to just take a moment to reiterate our support for the position of the State Bar of Michigan Children's Law Section. The proposed language would ensure expedited judicial oversight of any decision placing a child in isolation and allow the court to remove the child from the facility if it determines that the isolation would be more harmful than other alternatives. Our support of these amendments is not merely about reduction, but ultimately elimination. We support strong, decisive steps to eradicate the practice from our justice system, and these amendments represent a significant stride in that direction, which we hope may be accompanied someday with a full culture shift in our justice system where we're treating children as children. For these reasons, we support these amendments. Thank you.
Thank you very much. Any questions? Thank you for being here today. Our last item is item number 4, ADM file number 2022-30, proposed amendments of MRE 702 and 804 regarding expert witnesses' testimony and statements against interests that expose a declarant to criminal liability. We have one person speaking in person, Dominica Convertino from the State Appellate Defender's Office. How did I do? Did I get that right?
You got that perfectly right, Madam Chief Justice. Thank you. And good morning, Your Honors. May it please the Court, Dominica Convertino with the State Appellate Defender Office. I'm here today to express our office's support for the 2 proposed modifications to the Michigan Rules of Evidence, Rule 702 and Rule 804. In short, both of these modifications simplify the rules by reducing the level of ambiguity within the rules, and also it brings the rules more in line with the federal rules of evidence and their specific counterparts in those rules. Beginning first with Rule 702, which concerns the admissibility of expert witness testimony at trial, the current iteration of the rule places an emphasis on the principles and methods that are employed by expert witnesses, and the modified language would instead shift the emphasis away from the principles and methods and onto the opinion that the expert purports to have derived from a reliable application of those principles and methods. And this is a very subtle but important shift. And I think that it's best described by Michigan's Task Force on Forensic Science, which is the body that proposed this modification. That body, in its 2022 report, which included reference to this modification, had indicated that by simplifying the language, it would allow for trial courts to have a more precise rule or precise standard to apply in Daubert hearings. So by modifying this language for Rule 702, we would allow for more effective and smoother running Daubert hearings. We would improve the quality overall of those hearings here in Michigan. And in line with that sort of goal of reducing ambiguity within the rules and having a clearer standard to apply, the modification to Rule 804 similarly achieves that goal. So Rule 804B4 is a hearsay exception that applies when there is an unavailable declarant whose statement was made against his or her own interest. And when that statement is one that would expose the declarant to criminal liability, and when it is offered for the purpose of exculpating the defense or the accused, that statement must be supported by some corroborating circumstances of trustworthiness. And the modification here would simply remove the reference to the statement being offered for the purpose of exculpating the accused. And this is an important removal because the phrase itself doesn't really have any immediately apparent purpose. It actually, by removing it, furthers the goal that underlies this evidentiary rule overall, which is to ensure that when there is a statement made by a declarant who is not able to be at trial and therefore cannot be subject to cross-examination at trial, that that person's statement be corroborated by something that speaks to its credibility or its trustworthiness overall. And so overall, Your Honors, these 2 modifications reduce the level of ambiguity within the current rules. They bring the rules more in line with the federal rules of evidence, and in so doing, this would benefit the legal system overall because it would make it less likely that trial judges would render erroneous evidentiary rulings. And of course, for this court and for the Michigan Court of Appeals, that is a good thing because it would hopefully improve judicial economy overall. And for those of us who practice at the appellate level, it will take an important step toward ensuring that people's constitutional rights to a fair trial are guaranteed the first time around. And so for the foregoing reasons, the State Appellate Defender Office supports these modifications to Rule 702 and Rule 804, and I appreciate Your Honor's time this morning if there are no questions for me. Thank you.
Any questions? Thank you very much for being here, and the court is adjourned.